Texas. Emotions run high as 10 different defendants step forward to face serious charges, from violent crimes to offenses involving harm to others. Each case carries heavy consequences and real human stories behind the decisions made that there's no room for excuses or delays here. Judge West keeps the focus sharp and the process fine, reminding everyone that justice is not about comfort, it's about truth and accountability. What unfolds in this courtroom isn't drama for show. It's real justice, delivered without hesitation.
Okay. Mr. Radford?
Yes, ma'am.
You have Michelle Cormier?
Yes, ma'am. I just got the videos today that
Oh, you did?
Yeah, I just got 6 months today, the ones that we discussed.
We're waiting on. Okay. You can,
So if I can just get 30 days, I'll be able to announce.
if you'll just let her know that before she goes back. Okay, thanks. We'll reset Michelle Cormier so y'all can review those videos.
And I have Lively Stratton with Ms. Malfina.
Yes. Lively Stratton. I know, that's funny that you said that. No, you're not. Just made that up.
Guess I'm getting double teamed. Y'all double teamed. Yeah. I need another lawyer. I'm outnumbered.
Are you? I feel like you got it in you to. Right. Good morning. You're Lively Stratton Jr. And so Mr. Stratton in cause number 19-33601, charged with capital murder, and this we're back again on this. Mr. Radford has been appointed to represent Mr. Stratton. And Mr. Radford, have you had an opportunity to get started on discovery?
Judge, I have gotten a transcript. I've got a huge trial docket coming up in the next 2 months, and I haven't had a chance to read it. I have also visited with Mr. Stratton. I've gotten discovery from Ms. Malfino. I've gotten the paper discovery from Ms. Malfino, and we have visited preliminary,
Easy for you to say.
about a possible resolution to this case that doesn't involve trial, but we're going to have to do some further negotiations, and I think she has to visit with some family members.
Sure. And I know there's probably also some audio, video and things that you need to get. So obviously Mr. Stratton is going to take Mr. Radford just a little bit of time to get up to speed on this. And so what I'll do based on...
We've been working to recreate the file, Judge. It just was in several different places, including the district clerk's possession. I have prepared a written notice asking them for the trial evidence to be returned to the possession of the state.
Okay.
I also have the transcript thing.
I've gotten the transcript.
To Ms. Tanner, and we will begin going through that and recreating the file. If there's anything additional Mr. Radford needs, he knows I have no problem.
Judge, could I get 60 days on this?
Well, I was thinking for sure 60.
Yeah.
I mean, I think realistically, obviously it's going to take you some time to get up to speed, get the file recreated. We don't want to put it off too long. We need to get it taken care of, but I know everybody needs some time. So we're in September. We're not in August anymore.
I've got 4 huge trials.
Well, so why don't we do this? Why don't we come back first part of December, which is about 70 days, 75 days-ish. Let's find out where we are. And at that point, if you guys could at least have an idea if it's going to trial, then we can get a special date next year so that everybody's ready and available, and we'll get it set at that point if we need to for trial.
Yes, ma'am.
Okay? All right. Thank you. You can go back with the bailiff. 24 DCCR 2418 is charged with murder. What is the announcement?
Your Honor, any prayers in the objection 35 years, may I see stay on the trial docket. We have everything.
Okay. So there's no other negotiations. And Mr. Dodd, we've already gone through what you're charged with, what the possible consequences are if you go to trial, and you visited now with Mr. Burbank and you want to go forward with your trial. Is that correct? Okay, we'll get it set on the next available trial docket, and we'll see you then.
There is a co-defendant if you want to go together.
I don't know that we're worried about keeping them together. Yeah. Okay, thank you. All right, you can go back with the bailiff. And then you've got Traylon Hill. Not for me, for somebody else, unfortunately.
Good morning, Your Honor.
Good morning. How are you?
Doing great.
This is just for to go to whatever. Do you have the orders on those Burbank's motions? Good morning, you're Traylon Hill. And Mr. Hill, in cause numbers 24 DCCR 1500, 1614, 1615, and 25 DCCR 0436, Mr. Burbank has been hired, I believe, by your family to represent you. He has filed motions to withdraw in all of those cases. And so, do you have any opposition to me allowing him to withdraw? So, Mr. Burbank, you are released on all of those cases. Mr. Hill, because you are in custody, I will appoint an attorney today who can begin representing you and get ready for trial in all of your cases. All right, you can go back with the bailiff.
Missed a fun chance to talk about the
Is there? I didn't even. I think she printed it out for me, and I didn't even pay attention to it because it just gets me too riled up.
masturbate, threatening the cars. Growling and barking at cars.
Well, just more for you for the jury. I don't know. We got to figure out who to put on that one. Did we already talk about it?
Got you.
Probably. Where's Chip? It's either you or him or my go-to. So if you're off, it's gonna be it might be him. Yeah, and Matuska. Sometimes we'll throw Matuska because he's just so calm and he's like, okay, that might be a good one. He's so busy. I know that might be a good idea. Matuska, because he's just kind of calm. He's like, whatever, and Rapper's so busy over do some stuff, so maybe that might be a good one.
Didn't call.
Mr. Samuel, your ears burning over there?
A little bit.
You may want to talk to Mr. Burbank about what he's offering your services for up here. Kevin Ross. Kevin Ross, Mr. Burbank. I'm sorry. Okay, I'll hold it for just a second while they get that paperwork done. And then Carrington Scott. I see that one. We can do Carrington Scott now. already alerted me as well. Appreciate that. Let me get that pulled up the right way. Mr. Scott, in cause number 25 DCCR 0538, the state has elected to proceed on the lesser included offense of a state jail felony theft from a person, and that's from March 20th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, state's one.
It's admitted. Is there any evidence that Mr. Scott is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft from a person, sentence you in accordance with that agreement to a term of 180 days in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank.
One other thing.
Yes, sir.
This is a pending felony, misdemeanor, misdemeanor court. I don't have it, it's existing, this incident, and Mr. Smith said he was going to dismiss it as well.
Okay, and so Mr. Smith, you'll take care of that down in misdemeanor court, and they'll get that case dismissed quickly, all right? You can go back with the bailiff, sir.
And then call me when you have Mr. Ross.
I have it. We can get Mr. Ross out. Okay, that's fine. What? How many does he have? Please, ma'am. And I only see paperwork on one, though. Did y'all not do paperwork on both of Ross?
Just one.
1199.
What about the other MTRP?
Want me to do two?
They're both MTRPs. Yeah, you gotta. Yep.
You have to do offense, Judge. I have tendered the probable cause on that. It's yet to be indicted. Our proposal is before we're allowed for him to go to ISF. I was gonna hold that new case, see if he successfully completes it, and then take care of it later. I can have it indicted tomorrow, whichever the court prefers.
Okay, I'll look at it in just a second once y'all get all that done. Mr. Lewis, you have Norberto Armenta.
I believe that gentleman may have been hired on that one, so I was waiting to see if he showed up.
There's Mr. Kindler. Were you hired on a Norberto Armenta?
Not, I just looked in the case law.
Check the solution. Yes, I think he has two cases.
He does, and you were hired on both of those? I'm sorry, I didn't understand. Check that you are hired or check that it's been filed? You are. Okay, that's fine. I'll hold it. He's here and y'all can visit. Mr. Lewis, you've got Gerson Mendoza. swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English, so help you God. Thank you. Are there any immigration issues? Okay. I didn't see any listed in here. I just wanted to make sure. Jody, I'm not sure if I'm going to do this, but for Spanish speakers, non-English speakers, ISF, things like that, do they have accommodations for that? Okay, let me hold this for just a minute because that's something that I'm considering just based on age and the nature of the offense. If you'll just let them know, we'll pull him back out in just a second. Let's see, Hakeem Thomas, is that the one? There's a note here that someone turned their cell phone Saturday. Is that who? Gotcha. Okay.
Hakeem Thomas is the one that I was recently appointed to. That there was a conflict with Charlie, I think, and then Alan. I just got it last week.
Oh, you did? Okay. Have you had an opportunity to even visit with him yet?
I've talked with him. I visited with Ashley a little bit on the judge.
Okay.
And I've gotten some new information from his parents.
Okay, so we'll just do a normal reset on Hakeem Thomas if you'll just let him know, and that'll give you time to get caught up on that since you were just appointed. Thank you.
And Judge, that's the co-defendant that Mr. Parker had. We finally separated them last week, and they've got charges in other counties that I've been looking into. I'll make sure Mr. Lewis has the scope today.
Okay, thank you. See.
If you enjoy watching real courtroom moments unfold, make sure to subscribe and turn on notifications. Every week, we bring you authentic cases, powerful decisions, and the real emotions that play out when justice is on the line. Stay tuned as we explore how judges, defendants, and the law come together in stories that reveal the truth behind every verdict.
All right, sir, your Dalvius Williams. And Mr. Williams, in cause number 25 DCCR 0176, you're charged with a third-degree felony offense of injury to a child, and that's from October 28th of 2024. What that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you've signed with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 4-year term in the institutional division. I'm assuming that would run concurrently with the time that you're currently serving. You have every right to reject that and have a jury here and decide your case. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? I do want to make sure you understand, Mr. Williams, that after today, I will not accept this plea agreement. Once your case is on the trial docket, it'll go to trial, or you can change your mind and plea open to me or plea to something different, but it's not going to be this plea agreement. Do you understand? I just don't want you to think that you're going to sit in jail and things are going to get better somehow, right? Okay.
Judge, I'd also like to put on the record that if he was rejecting this offer on CC, the state will file this, whatever he receives in this jury, we stack on top of what he's already received.
So I do want to make sure you understand, depending on the timeline of all that, there is the possibility that if you're found guilty in this case and whatever punishment you receive could be stacked or run consecutively to that sentence that you already received. Do you understand? And do you still want to reject that offer and have your case set for trial? Okay, we'll get that done. Mr. Williams, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and appoint someone else today that can begin preparation for trial a little quicker. Is that okay with you? So, Mr. Rojas, you are released. Mr. Williams, we will appoint someone today, and they will begin preparation for trial. All right? You can get back with the bailiff. That may be one that we try to
probably his own attorney personality.
Yeah. When we have so many of those. But yes, I don't disagree with that.
It's your life, Charlie.
Get away from it.
We could have left you on.
I think me and her.
Yeah. Let's see. Kevin Ross, Mr. Burbank. That doesn't. Yeah. Good morning. Are you Kevin Ross? And Mr. Burbank, will your client waive the formal reading of the motion in each case? Mr. Ross, in cause number 24, DCCR 1198, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation December 18th of 2024 for the offense of deadly weapon in a penal institution, a third-degree felony, and that was a deferred probation for 4 years. Is that correct? It alleges that you, I'm sorry. And then I also have cause number 24, DCCR 1199, also a motion to revoke your unadjudicated probation. This shows that you were placed on probation December 18th of 2024 for evading arrest or detention with a motor vehicle, a third-degree felony, and that was also a 4-year deferred probation. Is that correct? Tell me again why we're doing this.
Just, DPS did bring the video in. They have yet to submit the case formally to be indicted on the evading. So our thought was to allow that to come in, maybe hold it, see how he participates in ISF. Certainly, based on the circumstances, we need to rediscuss it. We can. I don't believe he's had any write-ups while he's been in. I mean, obviously the new offense was quite egregious.
Well, and that's my. If you're on probation for that and then you do it again, six months after you were placed on probation.
No, I would only ask what you know, like charges still out of there. You can investigate depending on what the court wants to do. Come in front of the court again.
But if he pleads on it now, then I don't think even if it's indicted, I mean, if he pleads true today
Right.
to the new offense and I do what I do on these motions and reinstate and send them to ISF, if the case is then submitted or when it's submitted, you can't allege the same thing again and then me re-punish him for the same offense that he's already.
It's the new offense that you would address.
But y'all said that today. Count one is the new offense. I can't do it twice.
Well, once it comes back, once it gets indicted, then it can be addressed.
On its own, absolutely.
Yes, not the NTRP, but the new offense.
Well, I know, but then we have 2 probations and a new offense, and the argument then is going to be, we'll leave him on probation because you can't revoke him because you already did this. Because I already took it into consideration on these motions.
Leaving him on probation and then sending him to the penitentiary to do well on the new offense. See what I'm saying?
I know, but that's just, I mean, any word on where that is, why they're,
Reach out to them again. I know last time it was kind of in the context of that conversation.
yeah,
You want me to call them, you're gonna call them.
Yeah.
I can do that and I can get it to grand jury next month.
I just would like more information, I think, before, on that case. I don't think we need to have them on a probation and then those out there pending, and then in the middle of ISF, they send it. If a warrant's issued, they're gonna kick them out of ISF anyway.
These people got
it makes no sense to me. And from what I recall, it was not just a couple of blocks going slow. It was, okay.
I'll have investigator Bates reach out this morning, and we'll get it indicted by next week. Maybe an update would be beneficial.
That's what I'm thinking. I think I'm not going to just automatically do it. I think if there's going to be pleas, we can do an updated PSI. I want to know more about everything that's been going on before I agree to something like this. All right, you can go back with the bailiff. Would you put a sticky on that for me to contact DPS? Just do 3 weeks. I'm deleting the paperwork just because their dates will be wrong. So even if that's what y'all do next time, we're gonna have to do it again. Mr. Lewis, on Gerson Mendoza, Ms. Burge. I've got it over here. Alright, this is cause number 25, DCCR 0304. And are you Gerson Santa Maria Mendoza? Mr. Mendoza was previously in court, entered a plea of guilty to the first-degree felony offense of aggravated robbery. The agreement was for a 10-year deferred probation and a $1,000 fine. I've received the pre-sentence report and has everyone had an opportunity to review that report? Are there any additions or corrections?
No.
So, Mr. Mendoza, you're only 18, is that right? All right, so if I'm going to follow this agreement based on your age, the nature of the offense, the fact that you withdrew from school and haven't completed high school, I'm going to up front send you to the program called ISF. It's a 90-day program, and it is intended to help you to make better decisions. Because of your age, obviously, I want you to be successful on this probation, but I think there needs to be some involvement by other people to help you do better. Does that make sense? So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay the $1,000 fine and follow all of the rules and conditions of probation. That's including going to and successfully completing the cognitive track of the ISF program. If you do everything you're supposed to on this probation and you successfully complete it, this is a great opportunity because you don't have a conviction for a felony on your record. The other side of that, though, is if you violate any condition of your probation, you can be brought back into court, found guilty, so you would be a convicted felon, and you could go to prison for anywhere in the range of punishment, which is a minimum 5 years, up to the rest of your life in prison. Do you understand? Also, a condition of your probation is going to be that you get your GED. So once you get out of ISF, you're ordered to start that process within 45 days. Okay. All right, I'm handing you the trial court certification. That shows that this was an agreement that I followed. So you waived your right to appeal. Okay, good luck to you, sir. Thank you, Ms. Burge. Thank you. They might. You can let them know too. You might be able to start your GED in ISF. So check into it.
TDC doesn't.
Yeah, I just don't know if ISF does, but that would be good to get
That's
started.
where he's gonna be.
Yeah. Okay, let's see.
In today's busy session inside Judge Raquel West's Texas courtroom, every case told a different story about choices, consequences, and accountability. The day began with Lively Stratton Jr. facing a capital murder charge, one of the most serious offenses under Texas law, where a single decision could cost a lifetime. Then came Brandon Dodd, also accused of murder, as the courtroom carefully examined how his actions led to a devastating lost trail he'll follow next, not for a new offense, but for disciplinary problems while already in custody. A reminder that behavior behind bars can still shape a person's future. After that, Carrington Scott appeared on drug possession charges, listening as Judge West spoke firmly about accountability, choices, and the long road toward recovery. The focus then turned to Kevin Ross, who violated his probation more than once, pushing the limits of the court's patience. Philip Smith came up for a misdemeanor, a smaller matter, yet a clear example that even the lightest charge leaves a lasting mark. Norbert Amenta's hearing for felony drug possession showed the importance of fairness, as the court worked through language barriers to ensure full understanding. Similarly, Maria Mendoza's appearance required a Spanish interpreter, a small but powerful sign that justice must reach everyone, no matter their background. Haki Thomas's case was rescheduled after being assigned a new attorney, giving his defense team more time to prepare and ensuring the process stayed fair. Finally, Dees Williams faced one of the hardest charges to hear in any courtroom: injury to a child, a moment that brought silence and gravity to the room. From capital crimes to minor violations, Judge Raquel West handled each case with famed control and unwavering focus. Her approach stayed the same: fair, direct, and rooted in truth. That if you want to keep watching real courtroom stories like these, where every word, every decision, and every emotion matters, make sure to subscribe and stay tuned. More powerful courtroom moments are on the way.